happened.
Hello, Delky.
Hello, Ricky. How are you?
Doing well, doing well.
Go back if you want, Ben.
Great.
Oh. All right. Well, I might just do a quick introduction while we're waiting for a few more people to drop in and a little bit of housekeeping. First of all, I'm Alyce Zawacki. I am the current chair of the Entertainment Law and Sports section in Austin. As we kind of said, we had a lot of people here today that maybe haven't heard of us or maybe, aren't a member already. So if you would like to join, we would love to have you. We are a pretty tight-knit group. But everybody's always welcome, and we'd love to have more section members, absolutely. A little bit of, I guess, make sure your mics are muted. I'm sure we're all used to this by now if you're not speaking. Hopefully we will have some time at the end for a Q&A. But otherwise, it's kind of just going to be a bit of a panel and not anything too formal. But I'm really looking forward to discussing this important topic, and I really thank our panelists for being here today. Okay, quick introduction of our panelists. And if you see me looking away, it's because I have two monitors, so please excuse that. First of all, we have Ricky Anderson. Ricky received his JD from Texas Southern University's Thurgood Marshall School of Law in 1991, and he's owned his entertainment law focused firm in Houston since 1994. He's represented celebrities including Emmy, Academy, Golden Globe award-winning actors and Grammy award-winning musicians. Ricky has also been an adjunct professor at the Thurgood Marshall School of Law since 1998, where he lectures entertainment law, music industry contracts, and trial preparation. He's been the recipient of numerous awards. Really, his list is so impressive. If you want a copy of his bio, it's extremely impressive. His most notable award was the Presidential Lifetime Achievement Award, which he received from the Honorable President Barack Obama. He has served as an officer for various entertainment industry organizations and boards, and he's also the former CEO of the Black Broadcasting Network and CBS Records. So we're extremely glad to have you here today, Ricky. Thanks for joining us.
Thank you.
Then we have Sammetria Goodson. She also owns her own law firm, Goodson Law in Dallas, where she focuses on art law, fashion law, new media and design law, entertainment law, dispute resolution, and litigation. She holds a BBA in marketing and a BA in art history from UT and a JD from Temple University Beasley School of Law. She is a member of various arts and professional organizations and associations, including a pro bono attorney for Texas Accountants for the Arts, and I think we have Alyce joining us today, which is great, as well as the Philadelphia Volunteer Lawyers for the Arts. She also currently serves on the UT College of Fine Arts Advisory Council and is a frequent lecturer on topics of art law and best business practices for creatives, artists, and designers. In 2019, she served as a panelist at the Prism Art Fair during Art Basel Miami, and recently she served as the 2020 commencement speaker for the UT College of Fine Arts. So thank you for having us, joining us as well.
Thank you for having me.
And then we have James Scurlock. James works for DebnamRust Attorneys at Law. They have two locations, one in Austin and one in Dallas. He represents both defendants and plaintiffs in mediation, arbitration, and litigation across numerous areas of law in several states. Before joining DebnamRust, James worked for one of the top civil rights law firms in the United States and has extensive experience representing clients in civil rights, employment, and discrimination cases. His current practice also includes contract law, insurance law, real estate law, health law, veteran and military discrimination law, state civil rights violations, and tort law. James is admitted to practice in Texas, Arkansas, and Tennessee. He is also admitted to practice to the federal courts of the Northern, Eastern, and Western districts of Texas, as well as all of the federal courts in Arkansas and Tennessee. James is a member of several bar associations and is the past president of the Judge William R. Overton Inns of Court in Little Rock, Arkansas, and a present member of the Robert W. Calvert Inn of Court in Austin. James is happily engaged and getting married actually in this next month, which is super exciting, and he currently lives in the Austin area. So thanks for joining us, James. You're going to be great for some employment law background for all of us entertainment attorneys that typically don't know much about it. So thanks for joining us.
No problem at all. I'm glad to be here.
right, well, I think I'm just going to start the conversation by kind of getting all of your view on the current state of diversity and inclusion in the entertainment industry, kind of based on your own experiences.
In any particular order? Attorney Gooden, feel free to lead the way.
Absolutely.
So I would say in my current experience, which is folks who are both responding to the pandemic and the current movement for social justice, there's kind of three camps. So you have the folks who want to maintain the status quo of where we are with diversity and inclusion, wherever that is. And then you have folks who are interested in sort of a radical reimagining. And then the third group are the folks that are in the middle who I think see particularly the social justice movement as being an opportunity that is for marketing and PR purposes. So what I'm seeing from my clients, who are mostly artists and creatives, visual artists and performing artists, is that they're being reached out to for a lot of different opportunities. A lot of major brands and major companies are contacting them and seeking to work with them. But what I've seen, though, are deal points and contracts that I know aren't being offered to other folks. In my role, I represent a wide range of people, and so I can see these deal points coming in for different types of people. And so I may be responding to something I was even working on this morning, where I got a contract from a major retailer on behalf of a client, and I just knew that what was being offered to the creative and artists just wasn't market. So I would say, there are folks who are reaching out to artists to sort of maybe pull them into their current group of folks that they work with, but and that's great. That's wonderful, a wonderful response. But from my perspective, I'd like to see there be more parity with some of the deal points that I'm seeing coming out of the gate.
Absolutely. And Ricky, anything to add to that?
I think it's very important that we recognize the differential in what the climate has right now to offer. The one thing I do want to acknowledge is the current status is something that should not have to be raised. It really seems that globally, diversity should be addressed just across all of the industry, areas. And I just think it's important that we recognize, just as lawyers, that the Constitution really does have its place, and it's the best drawn document, for us as Americans that we could kind of live by. So seeing this swing in a direction of recognizing that there is some deference as far as, what's offered, who's working in the workplace, and recognizing, women and minorities from a diversity perspective, because my position is always fairness, justice, and it does not matter who's qualified, be it male, female, or what your ethnicity is. So I think it's important that we recognize that there's been a baseline for many, many years, and I'll always be the first to acknowledge that the Constitution is a great, unilateral contract, but it has been amended a few times, so there's always room for improvement. But with us working under the guise of fairness and justice, I think that it's important that everyone is given a fair, equal opportunity to work in this environment. And I mean, not only as lawyers, but in the actual production world, or if you're looking at it from an administrative perspective. So that's the only additive that I would certainly add to Attorney Goodson, is that it really is a space that should not have to be recognized. It should just be as a matter of fact that everybody's treated fairly.
Mm-hmm. And James, I'm sure you have a little bit of input on that.
Yeah, I mean, I think my comments probably feed more off of Ms. Goodson's comments. One of the things that I found, at least dealing with the entertainment industry, the little bit that I have, is it seems like, especially even today, and maybe even over the last few years, specifically in media companies, and I don't know exactly about advertising, so this may not be exactly the same areas Ms. Goodson has dealt with, but in the media areas, it seems like independent companies, especially independent film, and those areas seem to be, far ahead of a lot of the larger media companies and studios and what have you. with regard to recognizing the need for diversity, and for not just diversity, but for real portrayal of characters, having African Americans playing African American characters, Asians playing Asian characters, LGBT playing LGBT characters, and that type of thing. And there's always this hope that the larger media conglomerates are going to catch up, and that maybe some of these developments that have happened in the law recently, especially with the recent Supreme Court decision, is going to further that kind of level of diversity. And, you know, a perfect example of how diversity conflicted with diversity has happened might be very much the Halle Berry whole thing that happened, I think it was 2 or 3 months ago, when Halle Berry announced that she was going to be playing an Asian, and then quickly announced that she would not, because it was not a true portrayal of what an Asian person. And so in the media anyway, it seems to me, again, just to kind of summarize, it seems like the independents are a little bit ahead of the major studios, but I think that there's room for everyone to catch up.
Absolutely. And I guess on that point, I mean, who are the big players that are distributing and financing that is, diverse and isn't targeted to the mainstream white America? Are there people that are doing it really well? And maybe Ricky, this might be one for you. I know you work a lot in the film world, especially.
Sure. No, I mean, Universal Pictures, when you start looking at the bigger players in Sony, they certainly know that there's a market just about in every ethnicity that is unique in that, it's just that type of a property. But when you look even at television, I mean, we, E1, Stars, A&E, NBC, certainly with their new Peacock that launched last month in July, if you'll look at the programming, they're certainly reaching for, that streaming audience. So when I look at Fox, and where Fox has Fox News, but they've also got Fox Soul. So they're actually addressing all of the ethnicities and certainly the demographics. But, of course, it's now drifting from broadcast to streaming. So, the audience, by far will have an easier reach as far as, meaning easier reach and having access to the content. But just to name a few, I think that those are forerunners and have been for some time. I know the CW had always been, an advocate for diverse programming. But, again, I won't say that NBC, ABC, and CBS does not. It's just that there's a limited, platform presence for those types of assets.
Yeah, Sammetria, anything to add to that in terms of distribution and financing? I think definitely from my point of view, streaming has opened up, a very much wider range of content that we have access to, which is great.
Yeah. From the content creator side, what I'm encouraged by is what I term like the cross-pollination between the world of music and sports. I mean, you have folks like John Legend, who is behind the Underground series, with Misha Green as a showrunner. Also, you have LeBron James and Spring Hill Entertainment, who is behind a couple of productions. I think they just inked a deal. I got this date today. It was in June 26th, but they have been inking some pretty interesting deals. So I am encouraged that there are folks with financing and money coming in from some of the other industries like sports and music, who are reaching out to creators and making sure that on the content creation side that we're seeing more diversity. And I think that naturally bleeds over to the behind the camera, behind the scenes increase in diversity and inclusion. So that's pretty fun to watch, to see who's behind some of these productions that are coming out.
Yeah, that's a really good point. With individual investors that are able to then come forward and invest in streams that are important to them and content that's important to them. It's a great point to make. James, this is probably one for you. Can you please educate all of us entertainment attorneys on employment law and what we should really be kind of aware of in terms of what's prohibited, especially, in light of the new recent Supreme Court decision?
Well, if I was going to educate you on all the employment law, we would need a whole day. There are about 35 major areas of employment law, but the ones that typically apply, I think, in the media are likely going to be anything from general employment laws for extra, like that, who may be participating in production, which might get you into state and federal minimum wage considerations, and just making sure that everybody's being paid appropriately, or if they're an independent contractor, making sure that the independent contracts are properly crafted to make certain that no one could ever think that they were, in fact, an employee of the company. But with the most, the big topic and the thing that everyone's so interested in right now is really the extension of Title VII, or what people call the Civil Rights Act, to cover LGT. And I'm always very careful when I tell people that B isn't covered in the Supreme Court decision, and neither is the plus. And so L, G, and T are now covered specifically, and that being lesbian, gay, and transgender people are covered now under Title VII, much in the same way as women were previously covered, as African Americans and other people of color were previously covered. And so a lot of what's going to be playing out in entertainment law, as well as in general employment law, is how far does that go? Does this include things like harassment, and what types of specific discrimination are going to pull these in? Are these rights going to be extended out to asexual, non-binary, and others based on a gender interpretation of this law? And so those most recent developments are the things that a lot of people like me are very excited about. I was happy to file the first EEOC case for transgender discrimination under the law the day of the decision coming out, and very quickly the other side settled the case. They did not want to make precedent, so the EEOC was filed, the case was over. So those types of things are definitely going to be playing out as we continue on. And I think one of the ways that this is going to end up being addressed in the entertainment market goes back to something that Mr. Anderson said. And I'm going to kind of paraphrase a bit what you said and maybe condense it a little bit. This type of kind of niche portrayal now that we have for all these different groups, and it used to be a bad thing, right? The word niche in entertainment used to kind of be, oh, you're kind of putting them into a box. You're moving them over to this one side. Now it's exactly what everybody wants. Everyone wants their own channel, more or less. That it's so personalized now in what you can go and watch on streaming and things like that, that I think this is going to increase the overall ability of people who are in LGBT and people of color and other underrepresented groups to be able to go out and find an outlet for their portrayal. So what we're going to have to be aware of as attorneys is probably a lot of the things like Ms. Goodson has already seen, talking about the different points that maybe some people are getting versus other people are getting, and then seeing if there's some sort of a pattern there in the entertainment industry about, and I'm sure that you've seen it all at this point, as well as Mr. Anderson, where you may have white actors being paid way more than people of color who have equal billing, or maybe the same thing with LGBT actors or with women. Obviously, that's been a huge issue in the entertainment industry, is sexual harassment in the entertainment industry over the course of the last 3 or 4 years. And so there's just, I guess, a lot going on. But the biggest deal being that we now have a huge spotlight as attorneys on the Civil Rights Act of 1964, which is now 56 years old, and now suddenly has this wonderful new life that's been pumped into it, that it now protects even more people than it ever has before. And then above and beyond the Civil Rights Act concerns, I think that you also have to always take into consideration disability issues with regard to actors, especially someone who becomes disabled during the course of production of something or during the course of a project, and whether or not you're going to be able to grant them accommodations for that disability based on what's expected of them in their contract, especially if they are in fact signed employees. I am very much aware of the fact that most of your industry probably involves independent contractor agreements and things like that, which takes them out of some of these coverages and maybe just into general contract breach or fraud. And so that may end up being the way that you end up addressing a lot of these issues. But with regard to general employment, this is how this kind of goes. Making sure that you can give these types of accommodations, and then hand in hand with that, Family Medical Leave Act. One of the weirdest things about this whole COVID situation are these strange FMLA laws that we now have, where people can take FMLA to take care of their kids. They can take FMLA if they are sick, or if someone that they are sharing a household with is sick. So there are laws currently on the books that have expiration dates that still apply to us, including this new FMLA law. And so it's a very interesting and complicated time to be in employment law. And so what I typically tell people who call me up and they ask me, hey, I got this guy that's got this issue. Can you just tell me what I should do? I more or less tell them, I think you need to let me talk to your guy and let me try to figure out what's going on, because what you're talking about touches on 10 different areas of possible law. And I need to, in my mind at least, kind of fill the buckets of the different areas that might be applicable and then give you a report on what this might actually be about. So there's a lot going on. It's very complicated. So just call me.
I was going to say, your advice is that if we have a client that thinks they've been discriminated against or has had some issues in this area, we need to just contact you, James.
Well, that more or less. And it also goes the other way. As you said in my introduction, I also help companies avoid discrimination. And so one of the biggest things that I've been doing is what I call preventative law, which is approaching companies with the opportunity to rewrite their handbooks, to bring them into compliance with the current dealings on federal law, as well as to make sure that what they're following, to the extent that we're talking about the state of Texas, that they are in fact following the state of Texas handbook guidelines as well, for very specific purposes. One of the most insane things about practicing in Texas is having this employment handbook from the governor that says, this is what you should do, but we're not giving any legal opinions. But at the same time, it's specific interpretations of state law where they're basically saying, if you don't do this, you're violating the law, but we're not giving you a legal opinion. So it's all about taking this kind of gray area information from the government, as well as knowledge of the general laws themselves under state and federal law, and making sure that employers know what they're doing and making sure that they are following their own policies, so that they never get to the point of having someone come to them and say, hey, I think you're discriminating against me. Or, hey, I think you violated this, crazy draconian law that's been on the books in Texas since 1978 that no one knows about, except me, because I went and Googled it. It's those types of things, I think, for employers as well. So really, it's both sides. Prevention, as well as dealing with those that have gone and decided to go and break the law and just didn't care.
Yeah, and I think you made a good point in there. I think a lot of entertainment clients, often they have contracts and they don't really understand what's in them or what the ramifications of the words and the terms and the clauses are, and how that can impact them negatively in the long run. On the topic of kind of contracts, I'd like to touch on inclusion riders. Frances McDormand's 2018 Oscar speech obviously gave great attention to this topic. Ricky and Sammetria, I'm sure you have a lot to say about inclusion riders and what they are and how they can kind of be implemented in entertainment contracts.
I'd be happy to talk about the inclusion riders, but before I go into that, I did want to kind of just comment on what Mr. Scurlock just mentioned in terms of the preventative measures for discrimination. There's a lot of discrimination that people experience that falls below the legal standard. It shows up in microaggressions, gaslighting, overt racial hostility. These things don't sometimes rise to the standards that would trigger, internal policies or even trigger the application of discrimination law. But I think that the preventative measures on the front end may help companies in whatever industries to address those types of issues, so that the workplace, the environment itself, is more diverse and inclusive and equitable. So I appreciate your efforts there on the preventative side of what you do. But inclusion riders are an interesting legal principle. Of course, people are familiar, a lot more people are familiar with it from Frances McDormand's 2018 Oscar speech, but I tried to trace back the origins. So I'm sure many people on the call here know that the origins of the inclusion rider came from Dr. Stacey L. Smith. She's over at the USC Annenberg School. And she, in her article, I think it was 2014, modeled the inclusion rider concept off of something called the Rooney Rule. So all the sports law attorneys here are familiar with the NFL's Rooney Rule, which came into being, I guess, around our implementation around 2003. So what Stacey L. Smith is essentially positing and putting forth to the entertainment industry is that at the end of the day, the on-screen portrayal should represent percentages of race and gender equality that we see in society. So the idea is that there would be A-list folks, actors, and different talent who'd be able to actually argue for the inclusion rider as something that would be added on to their typical contracts. And it's pretty interesting. I'll put the, I'll send over, I just sent over the link to the actual inclusion rider template that was published in March of 2018. So the attorneys on this are Kalpana Kotangal, who's from Cohen Milstein. It's Dr. Stacy Smith. It's French and Cox DiGiovanni, and then from Pearl Street Films. And then some other folks from the Annenberg Initiative. So if you click that link, it'll take you to the template, and you'll see that the inclusion rider template specifically goes into auditions as well as off-screen positions, casting for non-supporting roles. So it's behind the camera, in front of the camera, and then there's also a reporting requirement. So the idea is that if an A-list talent is able to negotiate even the consideration of something like an inclusion rider in their contracts, that over time will serve to increase diversity, inclusion, and equity in entertainment industry. So it's a pretty interesting concept. And in terms of application, it looks like there hasn't, I want to hear also from Attorney Anderson on this, but from my understanding, there's been some productions like Just Mercy with Michael P. Jordan, where the studios took the inclusion writers seriously, but it seems so far it's been more inclusion without the writer. And of course, there's been folks like Ava DuVernay and other showrunners who've been pushing those types of thoughts through way before Frances McDermott's speech. So it is pretty interesting development in the law.
Yeah, Ricky, would love to hear from you on this. I've been seeing as well inclusion writers popping up in the music industry in terms of festival lineups, which is a really interesting application. So yeah, Ricky, I'll head it over to you.
Sure. No, and that's exactly right. I mean, the inclusion rider that's there so that in these production agreements, as well as in the casting agreements, there is an assurance that there'll be a certain percentage in whatever that level of diversity is. And that's the other thing that you want to make sure that we recognize is that that level of diversity is really meaningful and not just in title, where, you'll give someone of a certain ethnicity a title, but they're really not actively engaging in providing those services when we know that there's many that are qualified to do so. And you want to make sure it matches to the actual property itself, because as we said, we've got so many genres of pictures. You've got to look at the cast. You've got to look at the production. And in some instances, you've got to look at the geography. I mean, there are some cities that are populated more heavily with one ethnicity versus another. So you've also got to look at who's available in those particular markets to work a project. And particularly when you're looking at New York, LA, and Miami, and some of the other markets, a lot of those workers or the staff are committed to other projects. So it's not really simplistic as just having it as a written rider. It's certainly a great asset to have so that we can now monitor some of the balance and having minorities put in places that at least reflects the work environment. And I just think that it's very important that with the announcement of it, as you said, in 2018, we really see it affected, because we can talk about it, but we don't necessarily see it in effect. And as you said, it may be inclusion without the rider, as Attorney Goodson says, but we really have to, as lawyers too, make sure that we're not stepping into that space that Attorney Scurlock is in, and where you look at it and it becomes more discriminatory. So to answer maybe some of the questions in your minds, does the inclusion rider work? It does indeed. Is it a necessary element or component? Apparently so, because we hear it being voiced. Should it be necessary? No, we should always look at diversity being implemented into every project, just in fairness and justice. But of course, that's why they've got lawyers like us to make sure that we're able to enforce those particular components in a contract, because the workers or the actors or the production company certainly wants to have diversity, and they've announced that publicly, and it's important that we allow that to take effect.
Absolutely, yeah. And then I guess in terms of other clauses that can be included in entertainment contracts as well, and James, I'm sure you can chime into this as well. Most favored nations clauses, moral clauses, anti-discrimination clauses. I mean, I know I personally am seeing a lot of those clauses come up a lot more now in contracts across the entertainment industry, not just in film. So any of those that you're seeing be effective and you know, having a good impact?
Well, I'll chime in on the anti-discrimination clause specifically. I'm aware of the fact that those have been in there. I haven't ever been approached by anyone telling me, hey, look, I'm trying to do something because of an anti-discrimination clause in someone else's contract or in a general contract. I think it maybe what would be the best thing for me to address is just what you should do if you felt like there is such a clause that's been violated, or if you feel like you've been discriminated against in general. And this goes a kind of above and beyond attorneys. It's kind of the process. If there's a problem and you feel like you've been discriminated against, typically the law will require you to go to someone inside the organization to try to remedy it. It's kind of the same thing almost as contracts, where most of the time when you think there's a breach, you try to get someone to remedy it first. And so that might be human resources, that might be the showrunner, it's whoever basically is in charge. If that is futile, and that's especially true if it ends up that is the person who's causing the discrimination, then you don't have to necessarily go internally for a resolution, and you can start looking for an attorney. You can tell your clients they can do that, or they can file a complaint with the EEOC or with the Texas version of that to go and begin an overall investigation of what the allegations are. And then once those allegations have been investigated, then you can look to actually go into a regular lawsuit. But it always brings up the question, are you entitled to these rights if you're in an independent contract situation? And the answer is basically no, you're really not. And the reason why is because you're not an employee. The Civil Rights Act is all built around the idea of you being an employee working for an employer, not a contracted person working for someone who contracted you. And so you end up going into contract enforcement, which is what you guys are all probably very brilliant at, going and enforcing entertainment contracts. So I'm on the periphery, I guess, on some of that stuff. I can help out when you're concerned about the discrimination process and whether or not they've gone through it properly. But a lot of this, I think, a lot of these riders and other issues you guys are talking about, I think a lot of them get resolved in contract breach and in contract fraud issues, especially for independent contractors and people who've been signed on to do specific things.
Yeah, Sammetria, anything to add on there in particular in relation to most favored nations and moral clauses?
You know, my initial thought is that we've had most favored nations clauses, morals clauses, and anti-discrimination clauses for a while. And so if they are as effective as they pretend to be, then, you know, the idea of an inclusion rider and some of the other concepts that we're discussing today, I'm sort of questioning how effective those clauses are with catching particularly discrimination that doesn't rise to either the legal standard or the contractual standard, and whether or not that's actually moved the needle in terms of diversity and inclusion. So if I know most favored nations clauses comes to us in the entertainment space through, you know, international law. We've had them for a while. So if they're working, then I think we'd see some different results. That's just my general impression. I'm encouraged by the idea of the inclusion rider, specifically because of the types of conversations that it is encouraging. And in terms of some other things that may be done from an industry standard, I'll share another link. I am also in the fashion world. So I represent models, I represent fashion brands, and the Model Alliance, just shared another link, is an organization that is really rethinking and responding to the Time's Up movement that has happened within the modeling industry. As you can imagine, there are a lot of things that can go on in that world when it comes to sexual harassment. But in terms of an industry response, so not coming at it from discrimination laws, not coming at it from contracts, but coming at it from the industry standards. I think what the Model Alliance is doing is really interesting. The link I sent you is an infographic on the difference between It's the respect program, and you'll have on the infographic of versus. Well, the versus talks about corporate lawyers and drafting and self-serving codes of conduct. That's on the we don't like that side. On the respect side is models themselves drafting universal codes of conduct. So it's looking at the folks who are within the industry to say, this is what we would like in our working environment. I think it's a pretty radical idea. I mentioned there were kind of three main responses to diversity. It's folks who like the status quo and who benefit from it. It's folks who see it as a marketing opportunity, and folks who are about radical reimagining. I think what the Model Alliance is doing in the fashion industry is on that radical reimagining side. So that's what I would add.
Great, thanks for sharing that. Both of those links. Awesome. Michelle has a great question here. Michelle is one of our officers. She said, what's the latest thinking around provisions relating to artists, athletes, and public protesting? Are companies trying to use something that is in effect, such as a morality clause, to stop people protesting or having an opinion on it, I guess?
Well, I'll say one thing, and I'll just touch on one of the last items that Attorney Scurlock and Attorney Goodson had mentioned. When you look at these provisions, because it'll bleed into that question, but even more so now, a lot of these clauses are old clauses. I mean, when you've got a key man clause, and a lot of the larger talents that have the larger producers or directors, they'll say, if that producer or that director departs, then I go along with them. So it really does bind together a production based on trust. And that's one of the things too, that when you look at a lot of the claims that are being asserted, it does not necessarily go between two parties that have known each other. I won't say that it doesn't in total, but largely it's going to be, that person that you don't necessarily have a binding relationship with. So I certainly wanted to raise that component. And then secondarily, the termination clause that's been around forever. And many of the entertainment contracts will say, well, you're locked for life, even though something may be, contrary to what you anticipated that property to be. So in asking her questions, as things change, when you look at everything from a movement, be it Black Lives Matter, the Me Too movement, those are some of the components of a movement. The protest is just a protest, but you've got legislation, you've got those that are funding, so there's a number of pieces that fall right into the definition of filmmaking. So it's not just the person that's on screen or the producer, showrunner, or director. You've got investors, you've got corporate entities, and you've got the Universals and the Sonys and the bigger, even the Netflixes of the world that are very, very relevant when you start looking at how people are identified, treated, and what the interactions are. Because even when you look at it from the vantage point of putting your messaging on the jersey as they are, or making the statement and kneeling, or as they did back in the 60s at the Olympic Games, raising the fist, it's not new. It's been around, and we've got this thing called freedom of speech. And the question becomes, are we walking a fine line with freedom of speech in your workplace? And if you are, where is your workplace if you're shooting a film? Is it on social media, or is it actually on a set? So it does get a little murky, and I'll say, well, not necessarily murky, but it certainly gets cloudy. It turns gray, that line gets blurred in what that messaging is, who it may offend, who it's being spoken to, and more importantly, when you've got the athletes, who is it being spoken for? Is it the team, since you're out playing with their jersey, or is it your personal opinion because you're now bannering it on the jersey that you wear that's owned by, one of the franchises? So I know that may have not answered the question exactly, but I did want to certainly add that it's a bit more to it than generic yes and no, because it does fill the room when you start looking at, opinions, and particularly because we take so strongly the Constitution of the United States, which certainly attaches itself to the flag and the United States, the American flag, and so forth.
Mm-hmm.
Alyce, I'll kind of play off of that. I think, in my opinion, the things that Ms. Goodson has said from the Model Alliance and the things that Mr. Anderson just said with regard to kind of being clear, it kind of comes down to another question that I know is about to come up. So I'm sorry if I'm jumping ahead of you, but the preventative issue, right? Having a clear policy as a company, production company, whatever it may be that you're hiring people into, having an absolutely clear policy about what you can or cannot do, what is specifically involved in you working for this organization, having something like that could make it where these riders become less and less necessary. If you had something like what the Models Alliance has, where they basically say, look, here's the policies that we are in favor of. Here are the policies that we're not in favor of. Well, that clears up. If a production company were to, take on something like that for actors and other entertainment people, and I'm sorry I keep on talking about the media, but that's the thing I know the most about of all this stuff. If you did that, then, and I'm going to borrow a word Mr. Anderson used that you said he didn't necessarily mean to use, but I think it clears up the murkiness. Because if the policy of the company that, you have a right to freedom of speech, you have a right to be able to go out and do these things, it also makes it very clear that if they're going to have as a policy, that they're going to have diversity, they're going to guarantee a certain amount of diversity, or they're going to aim to have a certain amount of diversity, again, as Mr. Anderson mentioned about diversity across geographic areas, based upon where the production is going to be occurring. If these all become policies of the company, and people can trust those policies by seeing them enact those policies without being forced to put them into contracts, then suddenly we have institutional change. And I think that's all what we really want. We don't really want to be involved in having our clients have to go file lawsuits to enforce riders, or having to go and file discrimination complaints because this is going on. If the policy is really truly adopted throughout the entertainment industry, all of a sudden, all of these issues start being resolved at the beginning before there's even a contract signed. And we're not as necessary, so maybe we shouldn't encourage this too much.
Yeah, and maybe that's coming from the union standpoint. Ricky, I don't know what you think the likelihood of SAG-AFTRA and some of the other film unions and music unions picking up a policy like this and enforcing it. Do you think that is something that we may see happen in the future?
I know they're actively engaging discussions about everything that's happened over the last 3 to 5 years, and it's really gotten a bright light, no differently than, what we've seen as far as the actual actors and production companies voicing when they get the biggest microphone in the industry, be it at the Academy Award or the Grammys. They're making it known that they're looking for change in their members, of SAG and AFTRA and the every one of the guilds, from directors to producers. And I think it's important to them that there's equality in the workplace. And because it's certainly important to us, and I agree with Attorney Scurlock, he could almost just drop the mic after that last statement, because we won't become necessary if it's enforced. And that's one of the points that I wanted to make. We can say it, but are we going to actively do it and engage it and welcome it? Because, there's a lot of things that we could talk about, but if we don't take an active stance and do something about it, we'll have this conversation next week, next month, next year, and probably next decade.
Well, and we've been having this conversation, for the better part of 50 years, and not because it wasn't needed before that. It's just now we actually could do it. Yes. Somebody said maybe there actually should be, real representation of people. Maybe African Americans shouldn't only be playing maids and butlers in these major production, studio. And so it's been going on, and we obviously see a progression, but is it progressing fast enough? Is it progressing to the point where it's caught up with society? And obviously not, or we wouldn't have these rights.
Yeah, and I do want to leave enough time for questions. We've got about 10 minutes left. So I think I'm just going to ask one more last question here. And that is kind of, what are some tips that maybe you all have for addressing these issues with our clients? Any resources, thought leaders that we can kind of push them towards and say, look, this is what you should be doing. This is what you should be aiming for.
Attorney Goodson and I talked yesterday, and I think Attorney Goodson, now's the perfect time.
well, my thought is, if you're an attorney in the entertainment industry, but before you look at any sort of laws, or before you look at any sort of policies, there's probably some reading that you could do that would be helpful. So I have 3 book recommendations. One is How to Be an Anti-Racist. This is by Ibrahim X. Kendi. There's also the book White Fragility, which is by Robin DiAngelo. And then there's the book Just Mercy by fellow lawyer Brian Stevenson. I think as the attorneys in this industry, our approach to even how we negotiate contracts, our approach to how we address these issues from our perspective in terms of what we can do, it can be informed by having information about what's been going on that's written from these different perspectives, because it absolutely finds its way in contracts. It absolutely finds its way even in negotiations when you're representing clients, to have an understanding of maybe how the other party is even viewing your particular client. And for the attorneys on the line who are representing the larger companies, who I work mostly on the artist side, but if you're representing the major companies, you know, there are a lot of resources out there, and you sort of pushing the conversation beyond, oh, well, what can we do to respond to discrimination laws, to what can we do from a preventative nature? You know, maybe reaching out to Mr. Scurlock would be a good step forward. Also, there's work by an attorney by the name of Jaya Thomas. She has an organization called Diverse Representation, and she's been raising some pretty interesting questions about the folks who are not just representing the artists, but the folks who are in the boardrooms, the folks not just behind the camera, but the ones who are at the production studios, who are walking the halls. And that's also important to the conversation as well.
Thank you. And I will put those resources in an email and send it out to everybody on the call today, so we can share them with everybody.
Thank you. Thank you.
The only thing I would chime in with off of what she just said was, having an attorney do a review of your current policies and your handbook, if you are in fact one of the companies that are employing these people, doing it at least once a year, if not twice a year, maybe every 6 months, to make sure that your policies and your procedures that you have internally are keeping up with the law. I mean, nobody, I don't think, expected the extreme level of openness with which the Supreme Court came down with these decisions. I myself had not bet that they were going to offer transgender rights, but they did. And so as a result of that, you know, just this huge jump that happened is a perfect example of, if you had current policies that are 6 months old, they're now out of date. And so, you know, companies staying on top of this is a practical step that they could do. And not trying to plug myself too much. There's plenty of other attorneys who do the same thing that I do. But having an attorney that does both plaintiff and defense work to be the person reviewing your handbook, I think, is a huge deal. The reason why is because I can look at your handbook and tell you all the ways I would sue you, while at the same time looking at all the ways that your handbook protects you from lawsuits. So having someone who can look at your handbook and make sure that your company and your policies, the way you're handling your contractors, the way you're handling your employees, etc., making certain that you're just in compliance with state and federal law is one of the best ways to avoid discrimination. And then obviously there's soft issues here as well, such as training, making sure that your lower level management staff and showrunners and other people like that are also aware of not only what the law is, but also what your policy is. And to the extent that there are riders with specific people that people are going to be working with, making sure they understand they've got to comply with those riders so that they can't claim ignorance later on.
Yeah, thank you. And Ricky, anything last to add before we get to some questions? If you have questions, please post them in the chat, or once we kind of get to finishing this last take from Ricky, we'll open up the floor.
Sure. No, thank you. I think it's important too, as a takeaway here today, is to understand that it's not just us against them, or these are the complaints and there's nothing good in this industry. You know, over the last 3 decades in my practice as 100% entertainment, I've had a great relationship with many of the really all of the companies that I've worked with. May have not closed a deal, but when you're working with NBC or Comcast or ABC or Walt Disney or any of them, they've got policies. And the one thing I can, represent is that they will listen. If, James has an issue, he can, talk with them about what that problem is. It doesn't make them right, but they'll always be receptive. So just know that us as negotiators and lawyers that really, conduct ourselves as such, we should always raise that issue. We've got a right to defend our clients, and be it representing the talent, be them A, B, or C list, or if some of the production companies or the streaming networks that we've had the luxury of representing, we've always been able to raise those issues, certainly get some dialogue going about, problems that you may have and that they may not be aware of. So just be mindful of that. I would be remiss if I didn't say that there's certainly some welcoming ears for us to, launch these complaints to, and to try to make it better, because that's what we're hired for, to represent that client and get their message delivered and seek change. So thank you, Alyce.
Thank you. Okay, if anybody has any questions, I might open up the floor. We've got about 4 or 5 minutes. So you can either post them in the chat, or if you want to unmic and ask your question, you're more than welcome. Surely we've got some questions. Anyone?
Alyce, that means we're really good. That means that you've got the dream team here.
We must have covered everything in great detail.
Well, I was typing, but I've decided it would be faster if I just spoke. So first of all, thank you guys. Thanks, Alyce, for putting this together, and the panelists for being on this. Super helpful. Love all the resources that people are sharing. So one question kind of more focused on us being in Texas, right? And how can we kind of make lemonade out of the lemons, right? So Hollywood and other places are kind of entrenched. Is there some advantage of being in a place where it's a little bit more, you know, kind of garage band, like they're, you know, like an indie film like this? Texas is sort of indie entertainment creation. Do you think that makes it easier to sort of make change or harder?
I think there's a place for it, and I've lived here in Texas all of my career, and I represent you. If I had a nickel for every time I was told that I couldn't practice entertainment law from Texas back in the 90s, I would have a pretty big jug of nickels. So know that it could be done. Certainly, that's number one. Number two, technology allows us to film and produce anywhere, and it's really not as expensive as it was 20 years or 30 years ago. So my answer to your question is absolutely it can be done in Texas. Absolutely, there's a huge Texas fund that Governor Perry put in place that was $80 million, and we spent almost $30 million of that between Dallas, Austin, San Antonio, and Houston. And then when Hurricane Harvey hit, $50 million of that got taken into the Harvey Fund. Well, that's been replenished as of 2019. So there's actually film fund revenue in the state of Texas at the Texas Film Commission that you could utilize to support, you know, your film properties. So be mindful of that. And I say, absolutely, go to work in Texas. Let's build Texas as an entertainment mecca. And the technology allows us to stream and do so much more these days than it did in the past, which gives us more outlets for content as far as distribution is concerned.
Alyce, I've got a question for Mr. Scurlock.
Yeah.
I want to go back to the classification issue between somebody being treated as an independent contractor versus an employee. And of course, you know, whether we've got constitutional protection for independent contractors. The IRS for years has been using a classification model of facts and circumstances that determine whether somebody is to be treated as an employee or an independent contractor. Do you think that that same sort of pathway could be used to backdoor somebody who is nominally an independent contractor into functionally an employee for Title VII purposes?
Yes. And the reason why is the IRS is using an old Supreme Court case called the Silk case, S-I-L-K. They've been using the Silk case as the standard for independent contractor law since I believe that was decided in 1943, 1945, somewhere in there. There's a huge split in the circuits on what an independent contractor actually is. And the reason why, as you probably already know, Mr. Fisher, is that there's a problem in the Fair Labor Standards Act in that an employee is defined in the negative. We see all the things that they aren't. And so everything that they are is just not included in there. The only circuit that has actually taken a stand on this is the Eighth Circuit, and I argued the case. It's Carlson versus Action Process. I argued that case to the Eighth Circuit, and the Eighth Circuit became the first circuit in the whole country to actually define exactly what an employee is and exactly what an independent contractor is based on a specific factors test that is 100% determinative. And so I'd be happy to talk with you offline about that if you're especially the one writing contracts. The Fifth Circuit hasn't come down yet on a specific standard. They've been all over the place. And I know because the attorney who was up against me at the Eighth Circuit argued the Fifth Circuit standard, which made no sense, to the point where one of the justices basically said, this doesn't make any sense. So why shouldn't we just go with Mr. Scurlock's standard? And I didn't really have a good answer for that. So the standard that we have in place, at least in the Eighth Circuit, where I also practice, is the one that I'm using for all of my practice in the Fifth Circuit. And the reason why is because the standard is specific. It is a bit more limiting for the employer than what you could stretch the Fifth Circuit decisions to say. But the problem is no one really knows what the Fifth Circuit's saying anyway. So why not take some authority and say, hey, this is what you should put in the contracts to guarantee that someone's an independent contractor. Use a standard that's harder than the Fifth Circuit, so the Fifth Circuit isn't going to turn you away and say, no, this is obviously an employee. But I could go, this is literally, I have taught a class just on this, a CL just on this, Mr. Fisher. So I don't want to take too much time by getting too much into the details. But there's a factors test that I could walk anybody through that would like to talk about it, and how you would want to craft a contract to ensure no one would ever think the person's an employee. But at the same time, going through those factors, you may find that there's also no way that you could legally make them an independent contractor.
Okay. Yeah, no, I'd like to talk to you further about that. Thank you.
Absolutely. Feel free to contact me offline.
Okay, well, we are just past 1. If nobody has any further questions, I might wrap it up. Feel free to reach out to me if you do have specific questions about this or about ESLABA or anything else. Thank you so much to our panelists. You guys have been absolutely great. This was a really productive discussion, and I feel like everybody has really gained a lot of information out of it. So appreciate you all.
Thanks for having me.
Thanks for having me.
Yes, thank you.
Thank you.
Thanks for inviting us, Alyce.
Thank you.
And it was nice to meet you, Ms. Goodson and Mr.
Yes.
Anderson.
Likewise,
Nice to meet you.
Scurlock. It's a pleasure. We shall do this again.
Yeah, I appreciate you saying I dropped the mic. That was nice.
Thank you, Alyce. We appreciate it. Thanks, everyone.
Thank you, guys.
Thank you, guys.
Goodbye.
Bye.